Good afternoon, everyone. Today is Sunday, December 19th, 2021. This is Term of Use as it pertains to Priceline.com. Today, we will discuss whether or not the terms of use by Priceline demonstrates a valid contract. We will also discuss whether when a person visits the site, the visitor is bound to or should they have to agree to the terms. Next, we will discuss disputes and whether or not a person can sue. And last, we will talk about changes that can be made to possibly make the site better. Priceline.com is protected under United States and international, including trademark and copyright laws. Priceline operates a site and by visiting the site, objects a consumer to their terms and conditions of searching for products and service through their site. In Priceline's term of use, they describe their arbitration and dispute resolution disclaimers, liability, indemnification, chargeback, trademarks, copyright, and claims of copyright infringement. According to these terms, by ensuring that the terms are valid makes the use of their site engaging in a valid contract and also can upheld their by upholding their terms and agreement when visiting. This makes you valid to their contract via verbally. An agreement between private parties creating mutual obligation enforceable by law is the definition of a contract. By visiting their site, the consumer agrees to a mutual assent expressed by a valid offer and acceptance, adequate as consideration, capacity, and legality. This makes visiting the site bound to their terms of use. Priceline grants you a limited, personal, non-transferable, non-sub-licensable, revocable license to access and use this site only as expressly permitted in this agreement. Without reading the terms of use, a person verbally accepts the disclosure of visiting the website, which poses a great question. What would happen if a dispute occurred, and what would be the process of resolve? The main thing that a person has to remember is to ensure that the following terms of use, which allows Priceline the rights to resolve any problems. Unless prohibited by applicable law, any claim must be brought within 2 years from the date on which such claim arose or accrued. If unable to resolve your claim within 60 days of receipt, you may seek relief through arbitration or small claims court as set forth below. This informal process is a condition precedent to your ability to initiate a claim in Priceline. Because Priceline has a mandatory arbitration, this means that it is required that all claims must go through the arbitrator instead of any other source. A person can also choose to forego that arbitration and take the exception of bypassing the arbitrator and, with the terms of use in place, have to go through small claims court. A perfect example is Johnson versus Priceline, which plaintiff Lee Johnson and Joey Marie Kelly initiated a punitive class action in the United States District Court for the District of Connecticut against defendant Priceline.com, alleging that they latter failed to disclose to users of its Name Your Own Price, which is part of the booking service. Also, you would want to know that because they are based, they have their everything based out of Connecticut. The claim would have to be brought to Connecticut because this was part of their disclaimer and made set forth before they started before the website was truly known and truly out there. Plaintiffs sought compensatory, punitive, and equitable relief for alleging breach of fiduciary duty and contract. In this case, the appellate court concluded plaintiff failed as a matter of law to plead fiduciary relationship, thus demonstrating that the site can be sued, but there has to be definitive proof and a person has to follow the site policies set in place by the term of use. Although they have their terms of disclosure, it would be a great opportunity to add an acceptance to the policy like other sites. Most sites today disclose their terms of tracking through the acceptance of cookies, and something like this would be great to add to just visiting the site and accepting the rights to use the site. This would ensure that everyone knows about the terms of use and ensures that they have the opportunity to review before entering into an agreement to use the product and service presented by visiting the website. To me, this means that by letting the consumer know what's going on, they have the right to choose whether to truly use your site. Most people honestly don't read, so they miss out on a lot of things on knowing, and they actually violate their own rights because they have more rights in place, but because they didn't read and just went on and maybe followed up with the disclosure later, they realized that they have no claim, which is part of the defense of the website by adding this term. Overall, to me, Priceline does a great job with putting their terms of use into place and letting the consumer know what their rights and what the Priceline rights are. This has been terms of use in which pertaining to Priceline. And my name is Antonio Williams, and thank you for your time.